Forget New Year, New You. This season is about slowing down, locking the doors, and cozying up at home with the one you really want to do nothing with. Your dog. After the holiday chaos, those quiet nights with a blanket, a podcast, and your pup feel like the reset you actually need. Ollie helps make those moments easier with fresh protein-packed meals made from real human-grade ingredients, so your dog can enjoy some quality comfort food too. Choose from 5 recipes and get a personalized plan for your dog's needs. Meals arrive perfectly proportioned with a scoop and storage container, so serving is fast and mess-free. And with Ollie's in-app on-demand health screenings, supporting your dog is easy, ensuring more cuddles for many years to come. Visit ollie.com/truecrime and use code TRUECRIME for 60% off your first box.
The defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges, and this presumption remains with him throughout the course of the trial, the presentation of the evidence, throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence.
In my last episode, I covered what happened on May 25th, 2020, when George Floyd was confronted by Minneapolis police officers after they received a call about a possible counterfeit $20 bill. Here's what we know from the videos that were shown in court. Officers Lane and King first approach Floyd as he's sitting in the driver's seat of his car in front of the Cup Foods at East 38th Street and Chicago Avenue in Minneapolis. Floyd has 2 friends in the car with him. Officer Lane draws his weapon and demands that Floyd show his hands. Floyd puts his hands on the steering wheel, and Officer Lane puts his gun back in the holster. Lane then pulls Floyd out of his car. Officer King then assists him, and they walk Floyd across the sidewalk, where he then sits down. Officer King talks to him for a little over a minute, and then the 2 officers lift him up and walk him over to a squad car. This is where a struggle ensues inside the car, and you can hear Floyd begging them to not be put in the back seat and telling them he's claustrophobic. 2 other officers arrive, Officer Derek Chauvin and his partner, Officer Tu Tao. At some point, Floyd is put into handcuffs and removed from the vehicle. And then he is pinned down onto the ground. Officer King holds his back, and Officer Lane holds his legs, while Officer Chauvin places his knee in the area of Floyd's head and neck. Floyd can be heard saying, "I can't breathe," multiple times, as many as 27 times according to the prosecution. He is also heard saying, "Mama, please, don't kill me," and telling the officers that everything hurts. Then, after 9 minutes and 29 seconds, after the ambulance arrives, Officer Chauvin finally lifts his knee. Floyd is taken away in an ambulance, but is declared dead. Now, immediately after this occurred, the next day, the Minneapolis Police Department released a statement titled, "Man Dies After Medical Incident During Police Interaction." It went on to say that the suspect, quote, was ordered to step from his car. After he got out, he physically resisted officers. Officers were able to get the suspect into handcuffs and noted he appeared to be suffering medical distress. Officers called for an ambulance. He was transported to Hennepin County Medical Center by ambulance, where he died a short time later. Later that day, the 4 Minneapolis police officers involved were fired. Officer Derek Chauvin's trial started in March 2021 and just ended this past week. He was facing charges of second-degree unintentional murder, third-degree murder, and second-degree manslaughter. In Part 1, I covered the prosecution's case, the evidence they presented, and the witnesses they called to the stand. In Part 2, I'll go over the defense case, closing arguments, and the conclusion. This is Jillian, and in partnership with Law and Crime, you are listening to Court Junkie, Episode 154, Part 2. The first witness for the defense was Scott Creighton, a now retired Minneapolis police officer. But in May 2019, he was involved in a traffic stop that involved George Floyd. This was about a year prior to Floyd's death. Prior to his testimony, the judge gave the jury an instruction.
You are about to hear evidence of an occurrence involving George Floyd on May 6, 2019. This evidence is being admitted solely for the limited purpose of showing what effects the ingestion of opioids may or may not have had on the physical well-being of George Floyd. This evidence is not to be used as evidence of the character of George Floyd.
Creighton told the jury that he pulled over a red Ford Explorer on May 6, 2019, and approached the passenger side. The passenger was George Floyd.
I approached the vehicle on the passenger side. The passenger window was down. I started giving the individual that was in the passenger seat commands several times. The passenger was unresponsive and non-compliant to my commands. I then had to physically reach in because I wanted to see his hands because I couldn't see his hands. I reached in finally and grabbed his hand to put it up on the dash, and then that individual was taken from the vehicle and handcuffed.
Did you draw your service weapon?
Yes, I did.
The body cam footage from that incident was shown to the jury. Creighton can be seen giving commands to Floyd to remove his seatbelt and put his hands on the dash. Floyd says he's afraid of being shot. Creighton tells him that he's not going to shoot him, but he grows increasingly frustrated. Another officer yells at Floyd to spit out what you got and threatens to tase him. Creighton then pulls him out of the vehicle, and Floyd can be heard saying he's sorry. Creighton then tells him to relax and says, "You're not going to get beat up or nothing if you just follow what we're asking you to do." On cross, Creighton agreed that Floyd was following his commands and was awake, able to talk and walk. But he was incoherent in my mind, he said. Michelle Mosang was a paramedic who was summoned to the police station to tend to Floyd after his arrest that day. She testified that she spoke with him and learned that he had consumed opiates.
He told me that he had been taking multiple, like every 20 minutes. And it was I don't remember if it was Oxy or Percocet, but it was opioid based.
He had informed you he had taken some sort of an opioid every 20 minutes or something like that, correct?
And then another one as the officer came up.
She said she took his vitals. His blood pressure was high, and based on that and other issues, she recommended he go to the hospital. On cross, she said he told her that he had a history of hypertension and hadn't been taking his blood pressure medication for months. He told her he swallowed 7 to 9 Percocets throughout the day. She asked him why, and he told her he was addicted. She said he didn't want to go to the hospital, but agreed he was alert and obeyed commands. Shawanda Renee Hill was at Cup Foods on May 25, 2020, when she ran into George Floyd, whom she had used to date. She testified that he was happy, normal, talking, and alert. Floyd offered to give her a ride, and so they went out to his car. She then called her daughter, and in that time, Floyd fell asleep. She said employees from Cup Foods had come out to the car a few times, and she and their other friend tried to wake him up, but he would wake up and then fall asleep again. She then described when the police approached the car. She woke him up again.
So when I tried to wake him up, he woke up the second time. I said, "Floyd, the police is here. It's about the $20 bill wasn't real." I kept saying, "Baby, get up. The police was out." So he looked, and we looked to the right, and he had the police. He tapped on the window with a flashlight. And I'm like, Floyd. And so he turned back around again. He's like, what? And I was like, baby, that's the police. Open the door, roll down the window, whatever he told me to do. So he looked back, and when he seen the man had the gun at the window when we looked back to him. So he instantly grabbed the wheel, and he was like, please don't kill me. Please don't shoot me. What did I do? Just tell me what I did. Please don't kill me.
But I want to go back and just cover one thing quick, because where were you sitting in the vehicle?
In the back right passenger seat.
Okay. And so when officers came...
Back passenger seat.
Were there two officers that came to the vehicle?
Yes.
So one came to the passenger side and one to the driver's side?
Yes.
So initially you saw one officer to your right on the passenger side, correct?
No, I was up I'm trying to wake him up, so I'm in the middle, like at the time, when the police were there. That's how I was able to see him too, we both looked at the same time.
She said other than being sleepy, he wasn't acting abnormally. She said he was very startled when the officer pulled a gun on him. Peter Chang is a Minneapolis Park police officer. He said he responded to the scene outside Cup Foods on May 25th to assist. When he arrived, he was told it was a code 4, which means everything is under control. He saw Floyd in handcuffs sitting on the ground. But then he saw the officers start struggling with Floyd. And while that was happening, he testified that the crowd was getting more loud and aggressive. He said he became concerned for officer safety, that the crowd was very aggressive towards the officers. Parts of his body cam video were shown to the jury. When he first arrives at the scene, he walks over to where Floyd is sitting. Floyd is visibly and audibly upset, but spells his name for the officer. Officer Chang then goes over to Floyd's vehicle, where Floyd's two friends, Shawanda Hill and Maurice Hall, were standing outside of it. He stays there for a while, guarding the car and watching Floyd's friends. At some point, he tells them, "Right now, we're getting an ambulance for your buddy. He might have hurt himself." "Can I just see what y'all did to him? He's on the ground and everything," Shawanda can be heard exclaiming. "He's on the ground?" Maurice asks. Chang tells them that once his partners are done and come over there, they can ask what happened. Another officer then walks over and tells Floyd's friends that they can leave. On cross, Chang agreed that there were 4 officers there at the scene and that no one ever radioed for help. Barry Broad is a former police officer, instructor, and use of force consultant for the San Francisco DA's office. He said he reached out to the Minneapolis city attorney after Floyd was killed and offered his services. The city declined, and then he was retained by the defense. Broad testified that in his opinion, what Officer Chauvin did was not a use of force. He said his analysis has 3 parts: whether there was a justification for the detention, the level of resistance exhibited by the suspect, and what the officer did to overcome that resistance.
So in terms of your 3-part analysis, did you apply that analysis to this case?
I did.
In your opinion, was this a use of deadly force?
It was not.
Can you explain that?
So I'll give you an example that I used to teach my academy classes. So officers respond to a domestic violence situation, and the suspect is still there, and he fights with he fights with the officers, and the officers are justified in using a taser to overcome this person's noncompliance. They tase the individual, and the individual falls to the ground, strikes their head, and dies. So that isn't an incident of deadly force. That's an incident of an accidental death. And in my review, I would look to see whether the suspect's resistance to justify the use of the taser was objectively reasonable.
He said he felt Chauvin was justified and acted with objective reasonableness. He said there's an imminent threat factor, that you don't have to wait for it to happen. You just have to have reasonable fear. He also talked about pain compliance. If you're doing what I ask you to do, it doesn't hurt. If you don't do what I ask you to do, I can motivate you with pain compliance, stimulate you with pain. He said, unfortunately, criminals don't wear uniforms, so officers don't have the luxury of being able to look at someone and automatically determine if they're going to be a risk to them or not. As for whether alleged drug use has an impact on his use of force analysis, he said yes.
Because people under the influence of drugs may not be hearing what you're trying to ask them to do. They may not understand. Erratic behavior. They may have they don't feel pain. So techniques you would normally use to make somebody comply, they're not feeling. They may have superhuman strength, or they may have an ability to go from compliant to extreme noncompliance in a heartbeat.
Do you train officers to keep drug-influenced suspects handcuffed?
I do.
Why?
So there's been many instances where handcuffs were removed from a drug-influenced suspect, and as soon as they were removed, or some type of first aid measure started to be applied, the person is right back to fighting you, and you're in a fight for your life. So I've trained, and I've been trained, that when you're dealing with drug-influenced persons, they stay handcuffed until they're taken to a medical facility, if that's what the case may be, and they're put in soft restraints on a gurney so they can be treated.
He described the different levels of resistance officers encounter.
So no resistance would be compliance. That's always the goal. The next level would be passive resistance, where you tell the suspect, turn around, put their hands behind their back, and they don't. They're not resisting you. They're just being physically non-compliant, yet without any type of physical strength or any type of maneuvers that they may try to do to prevent you from handcuffing them. So the next level would be active resistance. So I go to put you into a handcuffing position and you pull your hands away, or you struggle with me. So that's active resistance, where they're using energy to prevent an officer from accomplishing their goal. And then now that same suspect who I want to handcuff pulls away from me and they swing at me. So that's active aggression. And all those cues are allowing me to start escalating up the ladder of force options I have available to me.
He said Floyd's level of resistance while resisting going into the squad car, quote, justified the officers to use even higher levels of force that they chose not to select. When asked about the officer's use of force after the squad car struggle, he said he doesn't consider a prone control a use of force. He said it's a control technique that doesn't hurt.
So when they brought Mr. Floyd to the ground, are you saying you don't consider that to be a use of force?
Up to that point, it was still a use of force, yes.
Okay. Once Mr. Floyd is on the ground, in your opinion, does there continue to be some level of resistance by Mr. Floyd?
Yes.
How would you describe that?
Active resistance. He was still struggling against the efforts of the officers. And I saw on one of the body cam videos that Mr. Floyd appeared to kick at Officer Lane.
Is there a reason why officers would take a suspect, actively resisting suspect, to the ground?
Yes.
Why?
So officers are trained that anytime you get resistance from a suspect or you're dealing with a high-risk suspect, it's safer for you, the officer, and for the suspect to put him on the ground in a prone position, face down, for a variety of reasons, some of which are it makes the suspect's mobility diminished. They can't get up and run as quick. It takes away some of the use of their hands, so they can't grab you without turning their body, which would give an officer time to react. It limits what they can do with their feet. They can still kick, but they don't have as much mobility or power that they would if they were standing.
He was asked if the fact that Floyd was handcuffed makes a difference for whether he should have been put in a prone control position. He said no. He also testified that the crowd, which he considers to be more than 2 people gathered for a common purpose, was vocal and was a potential threat to the officers. He said, quote, I felt that Officer Chauvin's interactions with Mr. Floyd were following his training, following current practices in policing, and were objectively reasonable. On cross, Steve Slisher asked him about how he said the prone position is not a use of force and didn't hurt. He asked if Floyd experienced pain, would that then be a use of force? If the pain was inflicted via the prone control, then yes, it's a use of force, he replied.
Looking then at Exhibit 17 and just starting with the fundamental premise of your testimony that what we're seeing here is not a use of force, I need to ask you if you believe that it is unlikely that orienting yourself on top of a person on the pavement with both legs is unlikely to produce pain?
It could.
What do you mean it could? Is it unlikely to produce pain or is it likely to produce pain?
I'm saying it could produce pain.
It could?
Yes.
And if it could produce pain, then, again, just looking at your premise, if it could produce pain, then it would be a use of force, wouldn't it?
If the officer's intent was to inflict pain, that would be use of force?
Not the officer's intent, sir. What you said is that it was unlikely to produce pain, and that's why it wasn't a use of force. You now just said that it could produce pain. And so, regardless of the officer's intent, if this act that we're looking at here in Exhibit 17 could produce pain, would you agree that what we're seeing here is a use of force?
Shown in this picture, that could be a use of force.
The prosecutor then walked through the videos with him, pausing at certain moments to ask questions.
Is there any non-compliance you were able to see in that clip?
In this clip, no.
And so he's not exhibiting non-compliance, and based on your testimony and your review and the plain video record in front of you, you see that the defendant has not changed his position, correct?
Correct.
He's still applying the same level of force that he did at the beginning of the restraint period, true?
That I can't say.
He's still kneeling on Mr. Floyd, correct?
Yes.
And you're not contending this was some sort of an accidental position, right? He didn't fall down onto Mr. Floyd, and he was purposefully kneeling on him.
Yes.
True? Okay. All right. And so, based on your view, right, of the defendant being on top of Mr. Floyd, up to this point and beyond this point, the defendant did not alter the level of force that he was using on Mr. Floyd, did he?
No.
Even though Mr. Floyd, by this point, had become, as you put, compliant. Fair?
More compliant, yes.
Well, what part of this is not compliant?
So I see his arm position in the picture that's posted.
Right.
That, a compliant person would have both their hands in the small of their back and just be resting comfortably, versus like he's still moving around.
Did you say resting comfortably?
Or laying comfortably?
Resting comfortably on the pavement.
Yes.
At this point in time, when he's attempting to breathe by shoving his shoulder into the pavement.
I was describing what the signs of a perfectly compliant person would be.
So attempting to breathe while restrained is being slightly non-compliant?
No.
No.
Dr. David Fowler was the former chief medical examiner in Maryland for many years. He told the jury that in a death certificate, there are two parts, a direct cause of death and contributing causes. He told the jury what his opinion is on how Floyd died.
So in my opinion, Mr. Floyd had a sudden cardiac arrhythmia due to his atherosclerotic and hypertensive heart disease, or you can write that down multiple different ways. During his restraint and subdual by the police, or restraint by the police. And then his significant contributory conditions would be, since I've already put the heart disease in part 1, he would have the toxicology, the fentanyl and methamphetamine. There is exposure to a vehicle exhaust, so potentially carbon monoxide poisoning, or at least an effect from increased carbon monoxide in his bloodstream, and paraganglionoma, or the other natural disease process that he has. So all of those combined to cause Mr. Floyd's death.
So Dr. Fowler says Floyd died from sudden cardiac arrest or cardiac arrhythmia caused by his heart condition during police restraint. He said secondarily, Floyd's drug use and even potentially carbon monoxide from the squad car contributed. He then said the manner of death is undetermined.
So this is one of those cases where you have so many conflicting different manners. The carbon monoxide would usually be classified as an accident, although somebody was holding him there. So some people would say you could elevate that to a homicide. You've got the drugs on board. He's got significant natural disease. He's in a situation where he's been restrained in a very stressful situation. And you put all of those together, it's very difficult to say which of those is the most accurate. So I would fall back to undetermined.
Dr. Fowler also testified about Chauvin's weight on Floyd.
You also, in reviewing the videos, you see that he has 2 feet on the ground with the exception of one small moment.
Yes, that was what I did actually see in the video.
So what portion of Mr. Chauvin's weight was transferred onto Mr. Floyd's body?
He's using a single knee technique through the greater majority. His other knee is either on the bicep area or on close to the left chest wall. So single knee tech, it's going to be less than 23%. But even if he applied both knees, which he would have transferred 23% of his body weight. For a 140-pound person, that would be between 30 and 35 pounds.
Less than 225 pounds from the laboratory experiment.
Yes.
He was asked about the placement of Chauvin's knee on Floyd's neck and if the structure of the neck was damaged. He said nothing vital was damaged.
In terms of the placement of Officer Chauvin's knee to Mr. Floyd, that Mr. Chauvin's knee in any way impacted the structures of Mr. Floyd's neck?
No, it did not. None of the vital structures were in the area where the knee appeared to be from the videos.
Well, generally speaking, do signs of injury play into your analysis as to the cause of death?
Yes.
How so?
Well, you make an observation of, such as in this particular case, of a knee providing force to a particular part of the body, and then you go and you look at the same part of the body to see whether or not you can find corroborating evidence within the body itself, either an abrasion to the skin, subcutaneous hemorrhage into the muscles, or other injuries that may be caused by the knee.
And what injuries did you observe in the photographs of Mr. Floyd?
All of his injuries were in areas where the knee was not. In other words, they were on the front of his body, his face, his places where he was restrained, but there was absolutely no evidence of any injury on the skin, to the subcutaneous tissue, or the deeper structures of the back or the neck.
Were there any broken bones, spinal injuries, anything of that nature?
There were no broken bones documented. I did not see a description of the spinal cord in the autopsy report, but given that there was really no external evidence of the area, the muscles around the spinal column, I would be very surprised if there was any spinal cord injury in this particular case.
On cross, Dr. Fowler agreed that he wasn't sure if the squad car was on or not, so he couldn't be sure about his carbon monoxide theory. He also agreed that even though there was no damage to Floyd's neck, the majority of times when someone dies from positional asphyxia, there are no physical markings or bruising.
Is it true, Dr. Fowler, that none of the prone restraint studies that you referred to actually studied subjects who had someone's knee on their neck in the prone position? Is that true?
That is true.
None of the studies went for as long as 9 minutes and 29 seconds. Is that true?
That is true.
After Dr. Fowler's testimony, Derek Chauvin was asked if he would be taking the stand. He said no and invoked his right to the Fifth Amendment.
His name was George Perry Floyd Jr., and he was born on October 14, 1973, in Fayetteville, North Carolina.
Prosecutor Steve Slisher gave the closing arguments on behalf of the state.
9 minutes and 29 seconds. 9 minutes and 29 seconds. During this time, George Floyd struggled, desperate to breathe, to make enough room in his chest to breathe. But the force was too much. He was trapped. He was trapped with the unyielding pavement underneath him, as unyielding as the men who held him down, pushing him. A knee to the neck, a knee to the back, twisting his fingers, holding his legs for 9 minutes and 29 seconds, the defendant's weight on him. The lungs in his chest, unable to expand because there wasn't enough room to breathe. George Floyd tried. He pushed his bare shoulder against the pavement to lift himself, to give his chest, to give his lungs enough room in his chest to breathe, with the pavement tearing into his bare skin. As he desperately pushed with his knuckles to make space so he'd have room to breathe, the pavement lacerating his knuckles. The defendant stayed on top of him for 9 minutes and 29 seconds. So desperate to breathe, he pushed with his face, to lift himself, to open his chest, to give his lungs room to breathe.
He told the jury that George Floyd asked for help with his very last breath, but Officer Chauvin didn't help.
The defendant did not help. He stayed on top of him, continued to push him down, to grind his knees, to twist his hand, to twist his fingers into the handcuffs that bound him, looking at him, staring down at times the horrified bystanders who had gathered and watched this unfold.
He told the jury that the expert medical witnesses for the prosecution all agreed that Floyd did not die of a drug overdose. He said the experts all agree and the videos showed that George Floyd did not die the way someone who dies from a fentanyl overdose dies. His breathing didn't slow down. He didn't fall asleep, didn't go into a coma. He said this looked nothing like a fentanyl overdose. He reminded the jury that according to testimony from a forensic toxicologist, the fentanyl levels in Floyd's system were, quote, well below the ratio of someone who dies of an overdose. That according to the testimony, the mean average level of fentanyl found in more than 2,000 people who were stopped for driving under the influence in 2020 was 9.69 nanograms per milliliter. 11 nanograms per milliliter were found in Floyd's blood. That same toxicologist also testified that people who are addicted to opioids have a higher tolerance and therefore take higher doses. Slisher said someone on drugs interacting with police may be a risk to officers, but it's not a threat and doesn't make what Chauvin did reasonable. He said policing is the most noble profession, and that this case is called the State of Minnesota versus Derek Chauvin, not the state of Minnesota versus the police. Policing is a noble profession, he repeated, and pointed to the several police officers who took the stand in the trial.
You met them. They took the stand. They testified. Make no mistake, this is not a prosecution of the police. It is a prosecution of the defendant. And there's nothing worse for good police than a bad police who doesn't follow the rules, who doesn't follow procedure, who doesn't follow training, who ignores the policies of the department, the motto of the department, to protect with courage, to serve with compassion.
This is not an anti-police prosecution, he said. It's a pro-police prosecution. Slisher then spoke to the jury about the murder charge. If you commit a felony level of assault and the person dies as a result of your assault, he said, you're guilty of murder. It's as simple as that.
And what the defendant did here was a straight up felony assault. This was not policing. It was unnecessary. It was gratuitous. It was disproportionate. And he did it on purpose. No question. This was not an accident. He did not trip and fall and find himself upon George Floyd's knee and neck. He did what he did on purpose. And it killed George Floyd. That force for 9 minutes and 29 seconds, that killed George Floyd.
He asked why Officer Chauvin did what he did in public, in broad daylight, why George Floyd's life was taken.
Well, this all started over a call of an alleged counterfeit $20 bill. But George Floyd's life was taken for something worth far, far less. Far less. You saw the photo. You saw the body language. You can learn a lot about someone by looking at their body language. Defendant facing down that crowd. They were pointing cameras at him, recording him, telling him what to do, challenging his authority, his ego, his pride. Not the kind of pride that makes you do better, be better. The kind of ego-based pride. But the defendant was not going to be told what to do. He was not going to let these bystanders tell him what to do. He was going to do what he wanted, how he wanted, for as long as he wanted. And there was nothing they could do about it because he had the authority. He had the power of the badge and the other officers. And the bystanders were powerless. They were powerless to do a thing. The defendant, he chose pride over policing.
In his closing arguments, Chauvin's attorney, Eric Nelson, told the jury that Chauvin is presumed innocent, and the burden of proving guilt is on the prosecution. He said the prone position is not a dangerous act, that it's routinely trained and used in the Minneapolis Police Department.
We can look at all of the other studies trying to determine this question is putting a subject in the prone position, even with officers on top, even with weight on top of the person, is that inherently dangerous? And the research says no. The practical experience says yeah, that says no. The prone position, when applied through a use of force, is not an eminently dangerous act because there is no evidence to support the notion that it was highly likely, that's the standard, highly likely to cause death. That is why the state has brought in expert after expert after expert to testify that the singular cause of death here is asphyxiation. Because if Mr. Floyd was asphyxiated as a result of the police restraint, he is liable for the natural consequences of that restraint, of his actions. But if any of these other factors come into it, if any of these other factors were substantial contributing factors of Mr. Floyd's death, because they were not the natural result of the restraint. If a person has drugs in their system and that drug causes an overdose, in the context of the police restraint, it's not the natural consequence of the restraint. It's the natural consequence of the deceased's actions.
He said human beings make decisions in highly stressful situations that they believe to be right. There are lots of what-ifs in this case, he said, but we have to analyze it from the perspective of a reasonable police officer at the precise moment with the totality of the circumstances when it comes to the use of force.
We have to look at the cause of death to determine, did Mr. Floyd die exclusively of asphyxia, or were there other contributing factors that were not the natural result of Mr. Chauvin's acts, right? Things that happened that were set in motion before Mr. Chauvin ever arrived. The drug ingestion, right? The bad heart, the diseased heart, the hypertension. All of these things existed before Mr. Chauvin arrived.
Nelson argued that the drug use was a factor in Floyd's death. For one, he said Chauvin responded as a reasonable officer would when confronting a large man who was, quote, possibly under the influence of alcohol or something else, as the initial call stated, and who was struggling with other officers. He pointed to testimony that officers are trained that people under the influence of certain drugs can become stronger than they normally would. He told the jury that even a small amount of fentanyl can be deadly, and that according to Floyd's friends who were in the car with him, he did fall asleep prior to the officers approaching. He insisted he wasn't making a point about Floyd's character and that millions of people struggle with opioid addiction. He also said that Floyd did not die of an overdose alone, but that it contributed, along with his existing heart disease. What role did the struggle play? He asked. He said, we know from Floyd's prior arrest, when he ingested drugs and struggled with the police, that his heart was beating at 219 over 160.
All of this, ladies and gentlemen of the jury, all of this, when you take into consideration the presumption of innocence and proof beyond a reasonable doubt, I would submit to you that it is nonsense to suggest that none of these other factors had any role. That is not reasonable.
He told the jury that when they review the evidence and the law as written, he said they will see that the state has failed to prove its case beyond a reasonable doubt. And therefore, Mr. Chauvin should be found not guilty of all counts, he said. The jury deliberated for a little over 10 hours before announcing they had reached their verdict.
We, the jury, in the above entitled matter as to count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. Same caption, verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty.
Guilty on all counts. After the verdict, George Floyd's family spoke to reporters. His brother, Philonise Floyd, became emotional as he spoke about the verdict and relayed it back to Emmett Till.
I feel relieved today that I finally have the opportunity for hopefully getting some sleep. A lot of days that I prayed and I hoped and I was speaking everything into existence. I said, I have faith that he will be convicted. Whew. It's been a long journey, and it's been less than a year. And the person that comes to my mind is 1955. And to me, he was the first George Floyd. That was Emmett Till. Wow. I did was on CNN with Deborah Watts, and she just brought him back to life. Wow. People forgot about him. Yeah. But he was the first George Floyd. Yeah. But today, you have the cameras all around the world to see and show what happened to my brother. It was a motion picture. The world seeing his life being extinguished. And I could do nothing but watch, especially in that courtroom over and over and over again as my brother was murdered. Times, they're getting harder every day.
George Floyd's other brother, Terrence Floyd, spoke too and said they appreciate the love they have received from people all over the world.
Oh man, I'm just grateful. I'm grateful that my grandmother, my mother, my aunts, they just got to see this history made. I'm grateful my brother's not here. I'm grateful and I'm proud of him. I will salute him at every day of my life. I will salute him because he showed me how to be strong. He showed me how to be respectful. He showed me how to speak my mind. I'm going to miss him, but now I know he's in history. Yeah. What a day to be a Floyd, man. Wow.
According to NPR, Derek Chauvin is believed to be the second officer to be convicted in an on-duty death case in Minnesota's history. In the days since the verdict was read, one of the alternate jurors has spoken out about the case. She said she was happy with the verdict, and for her, she didn't understand how it went from a counterfeit $20 bill to a death. She said she was convinced by the testimony from Dr. Chauvin. She also praised Darnella Frazier, the 17-year-old who had initially posted the video she recorded onto Facebook. She said, "Without her, I don't think this would have been possible." Derek Chauvin's sentencing hearing will be held in about 2 months. The trial of the other officers will be held in August. And that's all for these episodes. As you can tell, there was a lot of testimony to go through in this trial. And if you're interested in watching the trial in its entirety or checking out the highlights, go to Law and Crime's YouTube channel. I'll also include a link in the show notes. The testimony, especially from Dr. Chauvin, is really interesting. The graphics unfortunately don't translate too well on a podcast, but definitely check that out if you're interested. Don't forget to follow Court Junkie on Twitter at CourtJunkiePod, on Instagram at CourtJunkie, on YouTube at youtube.com/CourtJunkie, or you can always email me at podcast@CourtJunkie.com. To hear these episodes without the ads and to check out additional Court Junkie bonus episodes, go to CourtJunkie.com/support, which will redirect you to my Patreon page. Thanks as always for listening. Until next time.